Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. All right, so today on the podcast, we have some more expert evidence action coming your way. Today's decision is, okay, we ready? White, Burgess, Langille, Inman. And wait, did I miss some? What's the rest of it, Zach?
That's it, and it's the opposing parties, and it's and Haliburton and Co., I believe.
There we go.
Is the full,
it's too many names.
Full style of cause. Colloquially known as White Burgess to the rest
Everyone
of us.
just says White Burgess, so we'll just go ahead and call it White Burgess. So this one is sort of our current, as we sit here on September 6th, 2020, law around expert evidence in Ontario. And this is sort of your go-to case because it definitely summarizes all of the previous jurisprudence in this area, including RV Mohan, which we have talked about before. So this is, as we stand currently, the law around expert evidence in Ontario.
Mm-hmm. I remember learning about this in evidence, and I do remember this case because for evidence, to make a long story very short, I made a bunch of flowcharts for my exam. And I remember doing White Burgess because White Burgess has a great 4-step analysis. It's straightforward. It's simple. The court just lays it out. And I was like, 1, 2, 3, 4, done. And I still use it. I had to actually pull it up the other day for articling because someone was like, expert evidence. And I was like, White Burgess. But that's all I could remember at the time.
I must say, like, evidence is by far the class I use the most in all of my summer work, and so far in articling. I'm on week 10, I think, and I have used my evidence notes more than anything. Such a useful class. Oh my god, I feel like we're writing an ad now. This is not an ad read, but you should probably take evidence. Just
I would highly recommend it. Yeah.
But no, this is, I've written many a memo on this as well, and it's an interesting enough case. It's a civil case, unlike Mohan or Abbey, I believe, which are both criminal cases. It's interesting stuff, and it definitely is a masterclass in, how do you structure a decision so that it is the most easy to understand. I must say, especially reading these things out loud, it is almost evident right off the top when a decision is accessibly written and when it's not. Because let me tell you, when something is not written accessibly, it is impossible to read out loud. Oh,
absolutely.
It's terrible.
It's terrible because you'll go and you'll get halfway through what is a sentence and you'll be completely out of breath. Because and you'll just be like, it's tough.
Wait. Yeah, you're reading it and you're just like, wait, oh no. Uh-oh. And then, you have to go back because, they phrased it. Ugh.
Yeah, you lose the thread.
I could say endless words about some of these old decisions, especially some of, the early 90s decisions. They're unreadable. I'm like, who wrote this thing? This is terrible.
Which is why we're here, right? This is why we did the podcast.
Yes, exactly. Yes, we walk so you can run, pretty much.
Yeah.
But yes. White Burgess.
Yeah, and I think what's interesting, too, is White Burgess also, you already mentioned Abbey. Abbey's a great Anka court case.
Yeah.
Let me say that again. Abbey is a great Anka case that kind of spells out and fills out a little bit more of White Burgess and just kind of is more of a supplement and not really a change, if you could kind of frame it that way. And I think it's good to know as well. But if you at all are going to do any kind of litigation, soliciting work, anything that requires evidence, and you want to put an expert up, White Burgess is it.
Oh, definitely. Or even if you just want to remind yourself what the law is on expert evidence, White Burgess is totally my go-to. And then if you have a follow-up sort of niche issue within that, then you can, do further research on it. But White Burgess is definitely, I don't know, I feel like we stand the weirdest decisions, but this is such a well-written decision. It's just so clear, and that can be so rare. It's so lovely.
I know. And what I think is also interesting about it, too, is we have a civil decision. We see a lot of evidentiary decisions come down out of criminal law. And I think it's kind of refreshing to see one come out of the civil side because not everything we litigate is criminal law. It gets a lot of emphasis. It gets a lot of spotlight on TV and all that stuff. But really, civil law is a large body of court work. And a lot of decisions are made all the time in the civil courts that we just don't talk about.
Yeah, or in mid-courts as well. But yeah, I know. Once again, Law & Order lied to us so much. I feel so betrayed. But
oh, so betrayed.
But anyway, guys, enjoy White Burgess. It is a good one. White Burgess, Langille, Inman, and Abbot and Haliburton Company. Heard on October 7th, 2014 and April 30th, 2015. On appeal from the Court of Appeal for Nova Scotia. The judgment of the court was delivered by Justice Cromwell. Part 1. Introduction and Issues. Expert evidence can be a key element in the search for truth, but it may also pose special dangers. To guard against them, the court over the last 20 years or so has progressively tightened the rules of admissibility and enhanced the trial judge's gatekeeping role. These developments seek to ensure that expert opinion evidence meets certain basic standards before it is admitted. The question on this appeal is whether one of these basic standards for admissibility should be related to the proposed expert's independence and impartiality. In my view, it should. Expert witnesses have a special duty to the court to provide fair, objective, and nonpartisan assistance. A proposed expert witness who is unable or unwilling to comply with this duty is not qualified to give expert opinion evidence and should not be permitted to do so. Less fundamental concerns about an expert's independence and impartiality should be taken into account in the broader overall weighing of the costs and benefits of receiving the evidence. Applying these principles, I agree with the conclusion reached by the majority of the Nova Scotia Court of Appeal and would therefore dismiss this appeal with costs. Part 2. Overview of the facts and judicial history. A. Facts and proceedings. The appeal arises out of a professional negligence action by the respondents, who I will call the shareholders, against the appellants, the former auditors of their company. I will refer to them as the auditors. The shareholder started the action after they had retained a different accounting firm, the Kentville office of Grant Thornton LLP, to perform various accounting tasks and which, in their view, revealed problems with the auditor's previous work. The central allegation in the action is that the auditor's failure to apply generally accepted auditing and accounting standards while carrying out their functions caused financial loss to the shareholders. The main question in the action boils down to whether the auditors were negligent in their performance of their professional duties. The auditors brought a motion for summary judgment in August of 2010, seeking to have the shareholders' action dismissed. In response, the shareholders retained Susan McMillan, a forensic accounting partner at the Halifax office of Grant Thornton, to review all of the relevant materials, including the documents filed in the action, and to prepare a report of her findings. Her affidavit set out her findings, including her opinion that the auditors had not complied with their professional obligations to the shareholders. The auditors applied to strike out Ms. McMillan's affidavit on the grounds that she was not an impartial expert witness. They argued that the action comes down to a battle of opinion between two accounting firms, the auditors and the expert witnesses. Ms. McMillan's firm could be exposed to liability if its approach was not accepted by the court, and, as a partner, Ms. McMillan could be personally liable. Her potential liability if her opinion were not accepted gives her a personal financial interest in the outcome of the litigations, and this, in the auditor's submission, ought to disqualify her from testifying. The proceedings since have been neither summary nor resulted in a judgment. Instead, the litigation has been focused on the expert evidence issue. The summary judgment application has not yet been heard on its merits. B. Judgments below. Nova Scotia Supreme Court. Justice Pickup. Justice Pickup essentially agreed with the auditors and struck out the McMillan affidavit in its entirety. He found that in order to be admissible, an expert evidence, quote, must be and be seen to be independent and impartial, end quote. Applying that test, he concluded that this was one of the, quote, clearest of cases where the reliability of the expert does not meet the threshold requirements for admissibility, end quote. Nova Scotia Court of Appeal. Appeal Justice Belveridge and Oland concurring, Chief Justice MacDonald dissenting. The majority of the Court of Appeal concluded that the motions judge erred in excluding Ms. McMillan's affidavit. Appeal Justice Beveridge wrote that while the court has discretion to exclude expert evidence due to actual bias or partiality, the test adopted by the motions judge, that an expert must be and be seen to be independent and impartial, was wrong in law. He ought not to have ruled her evidence inadmissible and struck out her affidavit. Chief Justice MacDonald, dissenting, would have upheld the motion judge's decision because he had properly articulated and applied the relevant legal principles. Part 3. Analysis. A. Overview. In my view, expert witnesses have a duty to the court to give fair, objective, and non-partisan opinion evidence. They must be aware of this duty and able and willing to carry it out. If they do not meet this threshold requirement, their evidence should not be admitted. Once this threshold is met, however, concerns about an expert witness's independence or impartiality should be considered as part of the overall weighing of the costs and benefits of admitting the evidence. This common law approach is, of course, subject to statutory and related provisions which may establish different rules of admissibility. B. Expert witness independence and impartiality. There have been long-standing concerns about whether expert witnesses hired by the parties are impartial in the sense that they are expressing their own unbiased professional opinion, and whether they are independent in the sense that their opinion is the product of their own independent conclusions based on their own knowledge and judgment. As Sir George Jessel put it in the 1870s, quote, "Undoubtedly, there is a natural bias to do something serviceable for those who employ you and adequately remunerate you. It is very natural, and it is so effectual that we constantly see persons, instead of considering themselves witnesses, rather consider themselves as paid agents of the person who employs them." End quote. Recent experience has only exacerbated these concerns. We are all now too aware that an expert's lack of independence and impartiality can result in egregious miscarriages of justice. As observed by Appeal Justice Beveridge in this case, the Commission on Proceedings involving Guy Paul Morin report, authored by the Honourable Fred Kaufman, and the Inquiry into Pediatric Forensic Pathology in Ontario, 2008, conducted by the Honourable Stephen T. Gouge, provide two striking examples where, quote, "seemingly solid and impartial but flawed forensic scientific opinion has played a prominent role in miscarriages of justice," end quote. Other reports outline the critical need for impartial and independent expert evidence in civil litigation. To decide how our law of evidence should best respond to these concerns, we must confront several questions. Should concerns about potentially biased expert opinion go to admissibility or only to weight? If to admissibility, should these concerns be addressed by a threshold requirement for admissibility, by a judicial discretion to exclude, or both? At what point do these concerns justify exclusion of the evidence? And finally, how is our response to these concerns integrated into the existing legal framework governing the admissibility of expert opinion evidence? To answer these questions, we must first consider the existing legal framework governing admissibility, identify the duties that an expert witness has to the court, and then turn to how those duties are best reflected in the legal framework. Part C. The legal framework. 1. The exclusionary rule for opinion evidence. To the modern general rule that all relevant evidence is admissible, there are many qualifications. One of them relates to opinion evidence, which is the subject of a complicated exclusionary rule. Witnesses are to testify as to the facts which they perceived, not as to the inferences, that is, the opinions, that they drew from them. As one great evidence scholar put it long ago, it is, quote, "for the jury to form opinions and draw inferences and conclusions, and not for the witness," end quote. While various rationales have been offered for this exclusionary rule, the most convincing is probably that these ready-formed inferences are not helpful to the trier of fact and might even be misleading. Not all opinion evidence is excluded, however. Most relevant for this case is the exception for expert opinion evidence on matters requiring specialized knowledge. As Professor Tapper put it, quote, the law recognizes that, so far as matters calling for special knowledge or skill are concerned, judges and jurors are not necessarily equipped to draw true inferences from facts stated by witnesses. A witness is therefore allowed to state his opinion about such matters, provided he is an expert in them." End quote. 2. The current legal framework for expert opinion evidence. Since at least the mid-1990s, the court has responded to a number of concerns about the impact of the litigation process of expert evidence of dubious value. The jurisprudence has clarified and tightened the threshold requirements for admissibility, added new requirements in order to assure reliability, particularly of novel scientific evidence, and emphasize the important role that judges should play as gatekeepers to screen out proposed evidence whose value does not justify the risk of confusion, time, and expense that may result from its admission. We can take as the starting point for these developments the court's decision in the Queen and Mohan. The case described the potential dangers of expert evidence and established a 4-part threshold test for admissibility. The dangers are well known. One is that the trier of fact will inappropriately defer to the expert's opinion rather than carefully evaluate it. As Justice Sapinka observed in Mohan, quote, "There is a danger that expert evidence will be misused and will distort the fact-finding process. Dressed up in scientific language which the jury does not easily understand and submitted through a witness of impressive antecedents, this evidence is apt to be accepted by the jury as being virtually infallible and as having more weight than it deserves." End quote. The point is to preserve trial by judge and jury, not devolve into trial by expert. There is a risk that the jury will be unable to make an effective and critical assessment of the evidence. The trier of fact must be able to use its informed judgment, not simply decide on the basis of an act of faith in the expert's opinion. The risk of attunement to the opinion of the expert is also exacerbated by the fact that expert evidence is resistant to effective cross-examination by counsel who are not experts in that field. The cases address a number of other related concerns. The potential prejudice created by the expert's reliance on unproven material not subject to cross-examination, the risk of admitting junk science, and the risk that a contest of experts distracts rather than assists the trier of fact. Another well-known danger associated with the admissibility of expert evidence is that it may lead to an inordinate expenditure of time and money. To address these dangers, Mohan established a basic structure for the law relating to the admissibility of expert opinion evidence. That structure has 2 main components. First, there are 4 threshold requirements that the proponent of the evidence must establish in order for the proposed expert opinion evidence to be admissible. 1. Relevance. 2. Necessity in assisting the trier of fact. 3. Absence of an exclusionary rule. And 4. A properly qualified expert. Mohan also underlined the important role of trial judges in assessing whether otherwise admissible evidence should be excluded because its probative value was overborne by its prejudicial effect, a residual discretion to exclude evidence based on a cost-benefit analysis. This is the second component, which the subsequent jurisprudence has further emphasized. Mohan and the jurisprudence since, however, have not explicitly addressed how this cost-benefit component fits into the overall analysis. The reasons in Mohan engaged in a cost-benefit analysis with respect to particular elements of the 4 threshold requirements, but they also noted that the cost-benefit analysis could be an aspect of exercising the overall discretion to exclude evidence whose probative value does not justify its admission in light of its potentially prejudicial effects. The jurisprudence since Mohan has also focused on particular aspects of expert opinion evidence, but again, without always being explicit about where additional concerns fit into the analysis. The unmistakable overall trend of the jurisprudence, however, has been to tighten the admissibility requirements and to enhance the judge's gatekeeping role. So, for example, the necessity threshold criterion was emphasized in cases such as DD. The majority underlined that the necessity requirement exists, quote, to ensure that the dangers associated with expert evidence are not lightly tolerated, and that mere relevance or helpfulness is not enough, end quote. Other cases have addressed the reliability of the science underlying an opinion and indeed technical evidence in general. The question remains, however, as to where the cost-benefit analysis and concerns such as those about reliability fit into the overall analysis. Abbey introduced helpful analytical clarity by dividing the inquiry into 2 steps. With minor adjustments, I would adopt that approach. At the first step, the proponent of the evidence must first establish the threshold requirements of admissibility. These are the 4 Mohan factors: relevance, necessity, absence of an exclusionary rule, and a properly qualified expert. And in addition, in the case of an opinion based on novel or contested science or science used for a novel purpose, the reliability of the underlying science for that purpose. Relevance at this threshold stage refers to logical relevance. Evidence that does not meet these threshold requirements should be excluded. Note that I would retain necessity as a threshold requirement. At the second discretionary gatekeeping step, the judge balances the potential risks and benefits of admitting the evidence in order to decide whether the potential benefits justify the risks. The required balancing exercise has been described in various ways. In Mohan, Justice Sapinka spoke of the reliability versus effect factor, while in JLJ, Justice Binney spoke about relevance, reliability, and necessity being measured against the counterweights of consumption of time, prejudice, and confusion. Appeal Justice Doherty summed it up well in Abbey, stating that the, quote, trial judge must decide whether expert evidence that meets the preconditions to admissibility is sufficiently beneficial to the trial process to warrant its admission, despite the potential harm to the trial process that may flow from the admission of the expert evidence, end quote. With this delineation of the analytical framework, we can turn to the nature of an expert's duty to the court and where it fits into the framework. Part D, the expert's duty to the court or tribunal. There is little controversy about the broad outlines of the expert witness's duty to the court. As Anderson writes, the duty to provide independent assistance to the court by way of objective, unbiased opinion has been stated many times by common law courts around the world. I would add that a similar duty exists in the civil law of Quebec. One influential statement of the elements of this duty are found in the English case National Justice Compagnia Naviera and Prudential Assurance Company. Following an 87-day trial, Justice Cresswell believed that a misunderstanding of the duties and responsibilities of expert witnesses contributed to the length of the trial. He listed in Obiter dictum duties and responsibilities of experts, the first 2 of which have particularly influenced the development of Canadian law. 1. Expert evidence presented to the court should be, and should be seen to be, the independent product of the expert, uninfluenced as to form or content by the exigencies of litigation. 2. An expert witness should provide independent assistance to the court by way of an objective, unbiased opinion in relation to matters within his or her expertise. An expert witness in the High Court should never assume the role of an advocate. Many provinces and territories have produced explicit guidelines and related to the duty of expert witnesses. In Nova Scotia, for example, the Civil Rules of Procedure require that an expert report be signed by the expert who must make, among others, the following representations to the court. That the expert is providing an objective opinion for the assistance of the court, that the expert is prepared to apply independent judgment when assisting the court, and that the report includes everything the expert regards as relevant to the expressed opinion and draws attention to anything that could reasonably lead to a different conclusion. While these requirements do not affect the rules of evidence by which expert opinion is determined to be admissible or inadmissible, they provide a convenient summary of a fairly broadly shared sense of the duties of an expert witness to the court. There are similar descriptions of the expert's duty in the civil procedure rules of other Canadian jurisdictions. Moreover, the rules in Saskatchewan, British Columbia, Ontario, Nova Scotia, PEI, Quebec, and the federal courts require experts to certify that they are aware and will comply with their duty to the court. The formulation in the Ontario Rules of Civil Procedure is perhaps the most succinct and complete statement of the expert's duty to the court: to provide opinion evidence that is fair, objective, and non-partisan. The rules are also explicit that this duty to the court prevails over any obligation owed by the expert to a party. Likewise, the newly adopted Act to establish the new Code of Civil Procedure in Quebec explicitly provides as a guiding principle that the expert's duty to the court overrides the party's interests, and that the expert must fulfill his or her primary duty to the court objectively, impartially, and thoroughly. Many of the relevant rules of court simply reflect the duty that an expert witness owes to the court at common law. In my opinion, this is true of the Nova Scotia rules that apply in this case. Of course, it is always open to each jurisdiction to impose different rules of admissibility, but in the absence of a clear indication to that effect, the common law rules apply in common law cases. I note that in Nova Scotia, the civil procedure rules explicitly provide that they do not change the rules of evidence by which the admissibility of the expert opinion evidence is determined. Underlying the various formulations of the duty are three related concepts: impartiality, independence, and absence of bias. The expert's opinion must be impartial in the sense that it reflects an objective assessment of the question at hand. It must be independent in the sense that it is the product of the expert's independent judgment, uninfluenced by who has retained him or her in the outcome of the litigation. It must be unbiased in the sense that it does not unfairly favor one party's position over the other. The acid test is whether the expert's opinion would not change, regardless of which party retained him or her. These concepts, of course, must be applied to the realities of adversary litigation. Experts are generally retained, instructed, and paid by one of the adversaries. These facts alone do not undermine the expert's independence, impartiality, and freedom from bias. Part E, the expert's duties and admissibility. As we have seen, there is a broad consensus about the nature of an expert's duty to court. There is no such consensus, however, about how that duty relates to the admissibility of an expert's evidence. There are two main questions. Should the elements of this duty go to admissibility of the evidence rather than simply to its weight? And if so, is there a threshold admissibility requirement in relation to independence and impartiality? In this section, I will explain my view that the answer to both questions is yes. A proposed expert's independence and impartiality go to admissibility and not simply to the weight, and there is a threshold admissibility requirement in relation to this duty. Once that threshold is met, remaining concerns about the expert's compliance with his or her duty should be considered as part of the overall cost-benefit analysis which the judge conducts to carry out his or her gatekeeping role. Admissibility or only weight. The Canadian law. The weight of authority strongly supports the conclusion that at a certain point, expert evidence should be ruled inadmissible due to the expert's lack of impartiality and/or independence. Our court has confirmed this position in a recent decision that was not available to the courts below. Quote, "It is well established that an expert's opinion must be independent, impartial, and objective, and given with a view to providing assistance to the decision maker. However, these factors generally have an impact on the probative value of the expert's opinion and are not always insurmountable barriers to the admissibility of his or her testimony. Nor do they necessarily disqualify the expert. For expert testimony to be inadmissible, more than a simple appearance of bias is necessary. The question is not whether a reasonable person would consider that the expert is not independent. Rather, what must be determined is whether the expert's lack of independence renders him or her incapable of giving an impartial opinion in the specific circumstances of the case. I will refer to a number of other cases that support this view. I do so by way of illustration and without commenting on the outcome of particular cases. An expert's interest in the litigation or relationship to the parties has led to the exclusion in a number of cases. In other cases, the expert's stance or behavior as an advocate has justified exclusion. Many other cases have accepted, in principle, that lack of independence or impartiality can lead to exclusion, but have ruled that the expert evidence did not warrant rejection on the particular facts. Some Canadian courts, however, have treated these matters as going exclusively to the weight, rather than to admissibility. The most often cited cases for this proposition are probably the Queen and Clausen and Gallant and Brake pattern. Clausen holds as admissible any expert evidence meeting the criteria from Mohan, with bias only becoming a factor as to the weight to be given to the evidence. Similarly, the court in Gallant determined that a challenge to expert evidence that is based on the expert having a connection to a party or an issue in the case, or a possible predetermined position on the case, cannot take place at the admissibility stage. I conclude that the dominant approach in Canadian common law is to treat independence and impartiality as bearing not just on the weight, but also on the admissibility of the evidence. I note that while the shareholders submit that issues regarding expert independence should go only to weight, they rely on cases such as Inco that specifically accept that a finding of lack of independence or impartiality can lead to inadmissibility in certain circumstances. Other jurisdictions. Outside Canada, the concerns related to independence and impartiality have been addressed in a number of ways. Some are similar to the approach in Canadian law. For example, summarizing the applicable principles in British law, Justice Nelson in Armchair Passenger Transport Limited and Helical Bar Place underlined that when an expert has an interest or connection with the litigation or a party thereto, exclusion will be warranted if it is determined that the expert is unwilling or unable to carry out his or her primary duty to the court. The mere fact of an interest or connection will not disqualify, but it nonetheless may do so in light of the nature and extent of the interest or connection in particular circumstances. As Lord Phillips of Worth McRavers put it in a leading case, quote, "It is always desirable that an expert should have no actual or apparent interest in the outcome of the proceedings in which he gives evidence, but such disinterest is not automatically a precondition to the admissibility of his evidence." End quote. In Australia, the expert's objectivity and impartiality will generally go to weight, not admissibility. As the Court of Appeal of the State of Victoria put it, quote, "To the extent that it is desirable that expert witnesses should be under a duty to assist the court, that has not been held and should not be held as disqualifying in itself an interested witness from being competent to give evidence," end quote. In the United States, at the federal level, the independence of the expert is a consideration that goes to the weight of the evidence, and a party may testify as an expert in his own case. This also seems to be a fair characterization of the situation in the States. Conclusion. Following what I take to be the dominant view in the Canadian cases, I would hold that an expert's lack of independence and impartiality goes to the admissibility of the evidence in addition to being considered in relation to the weight to be given to the evidence if admitted. That approach seems to me to be more in line with the basic structure of our law relating to expert evidence and with the importance our jurisprudence has attached to the gatekeeping role of the trial judges. Justice Binney summed up the Canadian approach well in JLJ, quote, "The admissibility of the expert evidence should be scrutinized at the time it is proffered, and not allowed too easy an entry on the basis that all of the frailties could go at the end of the day to weight rather than admissibility," end quote. 2. The appropriate threshold. I have already described the duty owed by an expert witness to the court. The expert must be fair, objective, and non-partisan. As I see it, the appropriate threshold for admissibility flows from this duty. I agree with Professor Paciocco that the common law has come to accept that expert witnesses have a duty to assist the court that overrides their obligation to the party calling them. If a witness is unable or unwilling to fulfill that duty, they do not qualify to perform the role of expert and should be excluded. The expert witness must, therefore, be aware of this primary duty to the court and able and willing to carry it out. Imposing this additional threshold requirement is not intended to and should not result in trials becoming longer or more complex. As Professor Paciocco aptly observed, quote, if inquiries about bias or partiality become routine during Mohan voir dire, trial testimony will become nothing more than an inefficient reprise of the admissibility hearing, end quote. While I would not go so far as to hold that the expert's independence and impartiality should be presumed absent challenge, my view is that absent such challenge, the expert's attestation or testimony recognizing and accepting the duty will generally be sufficient to establish that this threshold is met. Once the expert attests or testifies an oath to this effect, the burden is on the party opposing the admission of the evidence to show that there is a realistic concern that the expert's evidence should not be received because the expert is unable or unwilling to comply with this duty. If the opponent does so, the burden to establish on a balance of probabilities this aspect of the admissibility threshold remains on the party proposing to call the evidence. If this is not done, the evidence or those parts of it that are tainted by lack of independence or impartiality should be excluded. This approach conforms to the general rule under the Mohan framework and elsewhere in the law of evidence that the proponent of the evidence has the burden of establishing its admissibility. This threshold requirement is not particularly onerous and will likely be quite rare that a proposed expert's evidence would be ruled inadmissible for failing to meet it. The trial judge must determine, having regard to both the particular circumstances of the proposed expert and the substance of the proposed evidence, whether the expert is able and willing to carry out his or her primary duty to the court. For example, it is the nature and extent of the interest or connection with the litigation or party thereto which matters, not the mere fact of the interest or connection. The existence of some interest or a relationship does not automatically render the evidence of the proposed expert inadmissible. In most cases, a mere employment relationship with the party calling the evidence will be insufficient to do so. On the other hand, a direct financial interest in the outcome of the litigation will be more of a concern. The same can be said in the case of a very close familial relationship with one of the parties or situations in which the proposed expert will probably incur professional liability if his or her opinion is not accepted by the court. Similarly, an expert who, in his or her proposed evidence or otherwise, assumes the role of an advocate for a party is clearly unwilling and/or unable to carry out the primary duty to the court. I emphasize that exclusion at the threshold stage of the analysis should occur only in very rare clear cases in which the proposed expert is unable or unwilling to provide the court with fair, objective, and non-partisan evidence. Anything less than clear unwillingness or inability to do so should not lead to exclusion, but be taken into account in the overall weighing of costs and benefits in receiving the evidence. As discussed in the English case law, the decision as to whether an expert should be permitted to give evidence despite having an interest or connection with the litigation is a matter in fact of degree. The concept of apparent bias is not relevant to the question of whether or not an expert witness will be able or unwilling to fulfill its primary duty to the court. When looking at an expert's interest or relationship with a party, the question is not whether a reasonable observer would think that the expert is not independent. The question is whether the relationship or interest results in the expert being unable or unwilling to carry out his or her primary duty to the court to provide fair, nonpartisan, and objective assistance. Having established the analytical framework, described the expert's duty, and determined that compliance with this duty goes to admissibility and not simply to weight, I turn now to where this duty fits into the analytical framework for admission of expert opinion evidence. Part F, situating the analysis in the Mohan framework. 1. The threshold inquiry. Courts have addressed independence and impartiality at various points of the admissibility test. Almost every branch of the Mohan framework has been adapted to incorporate bias concerns one way or another. The proper qualification component, the necessity component, and during the discretionary cost-benefit analysis. On other occasions, courts have found it to be a standalone requirement. Some clarification on this point will therefore be useful. In my opinion, concerns related to the expert's duty to the court and his or her willingness and capacity to comply with it are best addressed initially in the qualified expert element of the Mohan framework. A proposed expert witness who is unable or unwilling to fulfill this duty to the court is not properly qualified to perform the role of an expert. Situating this concern in the properly qualified expert ensures that courts will focus expressly on the important risks associated with biased experts. 2. The gatekeeping exclusionary discretion. Finding that expert evidence meets the basic threshold does not end the inquiry. Consistent with the structure of the analysis developed following Mohan, which I have discussed earlier, the judge must still take concerns about the expert's independence and impartiality into account in weighing the evidence at the gatekeeping stage. At this point, relevance, necessity, reliability, and absence of bias can helpfully be seen as part of a sliding scale where a basic level must first be achieved in order to meet the admissibility threshold and thereafter continue to play a role in weighing the overall competing considerations in admitting the evidence. At the end of the day, the judge must be satisfied that the potential helpfulness of the evidence is not outweighed by the risk of the dangers materializing that are associated with expert evidence. Subpart G, Expert Evidence and Summary Judgment. I must say a brief word about the procedural context in which this case originates, a summary judgment motion. It is common ground that the courts hearing a motion can consider only admissible evidence. However, under the Nova Scotia jurisprudence, which is not questioned on this appeal, it is not the role of a judge hearing a summary judgment motion in Nova Scotia to weigh the evidence, draw reasonable inferences from evidence, or settle matters of credibility. Taking these two principles together, the result in my view is this. A motions judge hearing a summary judgment application under the Nova Scotia rules must be satisfied that proposed expert evidence meets the threshold requirements for admissibility at the first step of the analysis, but should generally not engage in the second step, cost-benefit analysis. That cost-benefit analysis, in anything other than the most obvious cases of inadmissibility, inevitably involves assigning weight, or at least potential weight, to the evidence. Part H, Application. I turn to the application of these principles to the facts in this case. In my respectful view, the record amply sustains the result reached by the majority of the Court of Appeal that Ms. McMillan's evidence was admissible on the summary judgment application. Of course, the framework which I have set out in these reasons was not available to either the motions judge or to the Court of Appeal. There was no finding by the motions judge that Ms. McMillan was in fact biased or not impartial, or that she was acting as an advocate for the shareholders. On the contrary, she specifically recognized that she was aware of the standards and requirements that experts be independent. She was aware of the precise guidelines in the accounting industry concerning accountants acting as expert witnesses. She testified that she owed an ultimate duty to the court in testifying as an expert witness. To the extent that the motions judge was concerned about the appearance of impartiality, this factor plays no part in the test for admissibility, as I have explained earlier. The auditor's claim that Ms. McMillan lacks objectivity rests with two main points which I will address in turn. First, the auditors say that the earlier work done for the shareholders by the Kentville office of Grant Thornton served as a catalyst and foundation for the claim of negligence against the auditors, and that this precluded Grant Thornton from acting as independent experts on the case. Ms. McMillan, the auditors submit, was an irreconcilable conflict of interest, and that she would inevitably have to opine and choose between the actions taken and standard of care exercised by her own partners at Grant Thornton and those of the auditors. This first submission, however, must be rejected. The fact that one professional firm discovers what it thinks is, or may be, professional negligence does not on its own disqualify it from offering that opinion as an expert witness. Provided that the initial work is done independently and impartially, and the person put forward as an expert understands and is able to comply with the duty to provide fair, objective, and nonpartisan assistance to the court, the expert meets their threshold qualification in that regard. There is no suggestion here that Grant Thornton was hired to take a position dictated to it by the shareholders, or that there was anything more than a speculative possibility of Grant Thornton incurring liability to them if the firm's opinion was not ultimately accepted by the court. There was no finding that Miss McMillan was, in fact, biased or not impartial, or that she was acting as an advocate for the shareholders. The auditor's submission that she somehow admitted on her cross-examination that she was in an irreconcilable conflict is not borne out by a fair reading of her evidence in context. On the contrary, her evidence was clear that she understood her role as an expert and her duty to the court. The auditor's second main point was that Miss McMillan was not independent because she had incorporated some of the work done by the Kentville office of her firm. This contention is also ill-founded. To begin, I do not accept that an expert lacks the threshold qualification in relation to the duty to give fair, objective, and nonpartisan evidence simply because the expert relies on the work of other professionals in reaching his or her own opinion. Moreover, as Appeal Justice Beveridge concluded, what was incorporated was essentially an exercise in arithmetic that had nothing to do with any accounting opinion represented by the Kentville office. There was no basis disclosed in this record to find that Miss McMillan's evidence should not be excluded because she was not able and willing to provide the court with fair, objective, and nonpartisan evidence. I agree with the majority of the Court of Appeal, who concluded that the motions judge committed a palpable and overriding error in determining that Miss McMillan was in a conflict of interest that prevented her from giving impartial and objective evidence. Disposition. I would dismiss the appeal with costs.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.